Well, good evening, everyone. It's so wonderful to see you all here. Thank you so much for coming. My name is Alan Sens. I am a professor of teaching in the Department of Political Science, and I am the alumni director of the department. It's wonderful to see you all here this evening for the 2024 Mark Zacher Distinguished Speaker Lecture. I'm very excited to hear from our speaker this year, Professor Oona Hathaway. I would like to begin by acknowledging that we are gathered here together today on the traditional, ancestral, and unceded territories of the Musqueam people. This site on which UBC is located was the site of learning and community for the Musqueam people for many, many generations. And it is in that spirit that we are gathered here today, the political science community and our guests, faculty, staff, students, emeriti, alumni, all here together to carry on a very important legacy, the legacy of someone who believed very strongly in all of these collaborative and community-based efforts. So, on behalf of the Department of Political Science and the International Relations Program, it's my great pleasure to welcome you to the 10th annual Mark Zacher Distinguished Speaker Lecture. The Mark Zacher Lecture is an important part of our alumni programming calendar. We had a terrific alumni dinner and trivia contest on homecoming weekend this year. Some of you I know were there. We had a very engaging alumni conversations event on climate change and Vancouver in November. And we brought in the new year with our annual Politics to Watch alumni event in January. Tonight, we're so happy to be able to bring together so many of you for another opportunity to connect, to discuss, and to learn. Professor Mark Zacher. Made an enormous impact on the UBC Political Science Department, and as a beloved colleague, a director of the Institute for International Relations, and a wonderful mentor and role model for his many students. Mark was a prominent scholar in the field of international relations, and in light of the topic of tonight's lecture, it seems especially poignant to note that probably Mark's most influential work was an article he wrote about the international norm against using force to change the boundaries between states. This annual lecture was launched in 2013 and made possible by the generosity of key alumni and faculty who came together to honor Mark's legacy as a stellar academic and teacher. The concept behind this series was to create an annual public lecture in which a leading scholar or senior figure in the world of government and foreign policy would share their insights into key developments around the world. This annual lecture is meant to give audiences a chance to gain a better understanding of major events in the international realm through the lens of cutting-edge research in the field. I would like to say a huge thank you for all of you, all of those who made this series possible. Before introducing Oona Hathaway, I would like to provide you with an overview of the evening very quickly. Following Oona's presentation, we will have a brief Q&A where we open the floor up for your questions. I will take those questions and moderate. After the Q&A, we will hold a reception where there will be food and drinks in the outside foyer, and there will be an opportunity to mix and mingle with the many alumni, students, faculty, emeriti, and staff who have joined us this evening. One of the features of all of our alumni events is to create a space for people to connect with our political science and international relations community. Mark was a big believer in collaborative work amongst scholars, but he was also a big believer in community, and it is in that spirit that we gather here this evening. Oona Hathaway, who joins us this evening, is the Gerard C. and Bernice Latrobe Smith Professor of International Law at Yale Law School. She is also Professor of International Law and Area Studies at the Yale University MacMillan Center, Professor of the Yale University Department of Political Science, and founder and director of the Yale Law School Center for Global Legal Challenges. Professor Hathaway is also a non-resident scholar at the Carnegie Endowment for Peace. She's the director of the annual Yale Cyber Leadership Forum and a member of the Council on Foreign Relations. In 2014-2015, she took leave as a special counsel to the General Counsel at the US Department of Defense, where she was awarded the Office of the Secretary of Defense Award for Excellence. Tonight, Professor Hathaway will speak on the war in Ukraine and the past, present, and future of the global legal order, a topic very much at the core of Mark's work. Please join me in welcoming Professor Hathaway.
Thank you. That was so nice of you. Thanks. That was lovely. Thank you so much, Alan. And thank you to the department for inviting me and to all those who make this lecture possible. It's really a wonderful event, and I feel very lucky to have the chance to be here with you today. So my plan today is to talk about, as Alan rightly said, the war in Ukraine and the past, present, and future of the global legal order. A small topic. Obviously not going to be able to cover it all, but I hope to provoke a conversation and look forward to your questions and to the conversation that will follow. So this is my plan for the next 45 minutes or so. I'm going to start by introducing what I refer to as the old world order, sort of what did the world used to look like. It's very helpful, I think, to look back to better appreciate and understand what our world looks like today, because it's easy to assume that the way that the world exists today is how it's always been, or that it always must be. And I think once we look back, it allows us to see possibilities both by understanding what things looked like in the past, but also what they might look like in the future and better understand the present that we're in. Then I'll spend a little time talking about transformation from the old world order to the new world order, and I'll explain what I mean by that. Talk about the war in Ukraine as a test of this transformation in the global legal order and the challenges that it brings to our modern global legal system. And I will run through a number of the key challenges that we've already seen that have emerged in the now 2 years of war that have unfolded over the course of this conflict. And then I want to talk a little bit, just at the very end, about sort of what we can see so far about the impact that this war has had on the global order, but also the questions that remain to be answered before we really can be sure about where this is going to lead us. And it gives us a sense of the project that we have in front of us, of the challenges that our generation faces as this war continues to unfold. So that's the plan. So first, the old world order. What do I mean by that? Now, I'll just say that this is building on work in my book that I wrote with Scott Shapiro, The Internationalist, where we spend many hundreds of pages explaining all of this. So I'm going to be giving you kind of the bird's eye view of the transformation. But if you want to kind of deeper dive into this history, I encourage you to take a look at that. So if you studied international law at all, and I imagine most of you haven't, but if you've sort of had a passing familiarity with international law, you've probably heard the name Hugo Grotius. So Hugo Grotius is this figure who's often known as the father of international law. He's a real figure in my field of international law. There's the Hugo Grotius Lecture this and the Hugo Grotius Prize that. He is a kind of lauded figure. And he's often known as the father of what's called just war theory. And people think when they hear just war theory that he understood a just war in the way that we would understand a just war. But his vision of what a just war was a very different vision than I think what most of us would think is a just war. So in his world, war was a permissible remedy for wrongdoing. In his understanding, and this is a quote from him, war is just for the very reason that it tends towards the attainment of rights, and in seizing prize or booty, we are attaining through war that which is rightfully ours. Now, his vision was a world in which states would resort to war to resolve their disputes. And there was a whole range of different kinds of claims that states could make against one another. This is a list of the kinds of claims that states actually made. So this is not just a case of an academic, Hugo Grotius, kind of laboring away and nobody actually reading it or acting according to what he's saying. This is what states actually did. And this is gathered from a data set that I put together by gathering as many war manifestos as I could find. And these war manifestos are these remarkable documents that states used to issue before they went to war. They would issue these sometimes quite flowery declarations, explanations of the fact that they were going to war and why they were going to war and all the reasons that they were going to war. And in these documents, they would offer a host of different kinds of justifications for the war that was about to be launched. And so what we did is we read through all of these war manifestos. I had a team of research assistants that read through them and categorized the various reasons that they gave. As you can see, the top reason, self-defense, is a fairly familiar one today, right? That's the kind of justification you would hear today for a war. But the rest of these should seem like somewhat unfamiliar justifications for war in the modern era. Obtaining compensation for tortious injuries. So this is like, you broke my ship and you owe me money kinds of claims. Or enforcing treaty obligations. So there's a treaty obligation, you owe some obligation to me by virtue of this contract that we've entered into. You failed to live up to your side of the agreement. I can go to war against you to enforce that obligation. I can take territory, I can take land, I can take prizes, I can take booty, I can take what I want in compensation for the harm that you've done to me. And these are just a whole host of various kinds of reasons that were commonly given by states to justify the wars that they waged. And so in the old world order, the privilege to use force was at the kind of core of the international legal system. And what I'm going to say a few words about is how that then led to a whole host of follow-on rules that sort of necessarily were implied by that core obligation, or that core right. That is this privilege to use military force to right wrongs or to seize from other states compensation for the harm that had been done to them. So I'm going to talk a bit about rights of conquest, license to kill, neutralities, impartiality, and gunboat diplomacy. And I'm going to say a few words about each just to give you a sense about how this plays out. Hopefully, you'll come away from this thinking that the world was rather different then, although one question I will raise is, are we starting to backslide once again? So if war is legal, conquest is legal. This is President James Polk, who was president during the US war with Mexico. And the US launched this war. The legal justification for launching this war was that Mexico had failed to repay a set of debts that were owed to the United States. And in fact, the debts had been consolidated and agreed to through an arbitral process where the King of Prussia was the arbitrator. So there was a very elaborate legal process by which they settled on what the agreed upon debts were. Mexico had actually entered into an agreement to repay these debts on regular installments. It paid a few of them and then it defaulted, failed to pay on the rest of them. Polk demanded that Mexico pay. Mexico wasn't able to pay, partially because Mexico had gone through 32 governments in 31 years, so it was just extraordinarily unstable. So Polk was happy to have this justification to go to war because he'd always wanted to seize this territory, but he needed a legal justification, and this gave it to him. So he went and seized significant territory from Mexico, and now that has become a significant portion of the United States. Now, this is utterly reprehensible from a modern perspective and unacceptable and would be seen as totally illegitimate from a modern perspective. At the time, however, it's important to emphasize that this was sort of the ordinary course of business. This was normal behavior. This is what states did to one another on a very regular basis. And if you look at the maps from this era, the lines are moving all over the place. And they're moving all over the place in part because they're conquering and reconquering territory from one another. And they're doing that not just as a kind of violence that's untempered by law, but actually as a form of legal enforcement, an enforcement of the legal rules. Now, if war is legal, then gunboat diplomacy is legal. This is a woodcut drawing from the perspective of people who were in Tokyo at the time that Commodore Perry, this gentleman here, showed up with a steamboat, which most people in Japan had not seen a steamboat because Japan had been cut off from trade with the rest of the world for several hundred years at that point. And Commodore Perry had been sent by Congress to insist that Japan enter into a treaty of friendship, essentially. So at the point of a gun. And a treaty of friendship was under commerce and navigation. This was to allow for trade, and the US was trying to open up a port that it could use as a base to enter into Asia. It had been using Hong Kong, which was put it into kind of uncomfortable proximity to the British, and so they were looking for an alternative port and decided to force Japan to offer that port. And gunboat diplomacy was at the time perfectly legal. So essentially Commodore Perry shows up and says, you're going to enter into this treaty or else we're going to invade you, otherwise we're going to use force against you until you do finally enter to this agreement. Japan, through a long process, ultimately decided that it was going to concede. It didn't really have a choice, entered into the treaty, and then the treaty was itself enforceable through threats of force, through threats of war, because once you've entered into a treaty, the treaty is now an obligation that can be enforced with war. So if war is legal, then gunboat diplomacy is legal. If war is legal, that can't be a crime of aggression. After World War I, there was calls to try Kaiser Wilhelm II for the war, which he had played a significant role in starting. And the Dutch, of all people, refused to extradite him. Now, that's sort of funny because right now all the international criminal courts are in The Hague, and they are the home base of international criminal law right now. But at the time, they said, no, we can't extradite him because there's no such thing as an illegal war. There's no crime of aggression. There's nothing illegal here. There's nothing that he did that was illegal. And so therefore, there's no criminal act for which to extradite him, for which he could be criminally tried. There is no such thing as a crime of aggression because there's nothing illegal about the war. And so he was not extradited, he wasn't tried, there was no criminal process, there was no enforcement against him because there was no crime to enforce against him. And if war is legal, then states can't favor either side. They have to be perfectly neutral. This is a statement that President Woodrow Wilson gave when he ran for president. He sort of ran on the slogan, "He kept us out of war." Turned out he didn't keep us out of war for very long, because shortly after he was reelected, we were plunged into war. But he made the point in his speeches about the importance of maintaining neutrality and maintaining complete neutrality. And what this meant was that states could not put in place trade sanctions of the kind that are very common today, the sanctions that we're all familiar with, or favor one side and the other, provide arms to one side, provide assistance to one side. If you did that, that would violate your duty of neutrality, and that was illegal, and you would be automatically, and you would become a party to the war. You would become a belligerent in the conflict. So if war is legal, states can't favor either side, and they have to be totally neutral. Okay, so that's a kind of broad brush overview of some of the core rules of the Old World Order. Now I'm going to say a little bit about the New World Order, which is hopefully going to sound more familiar. And the way in which we got a transformation is it's relatively recent. So this figure is Salmon Levinson. If you haven't heard of him, you're in good company. Most people haven't. I hadn't heard of him when I started this project. But as I was trying to figure out when did this shift? When did we stop seeing war as a legal and legitimate means of enforcing legal rights and start seeing it as something that was illegal? It led me back to this character, Salmon Levinson. He was a figure who early on had this kind of crazy idea that he could stop war with law. He said that the real disease of the world is the legality and availability of war, and that we should have, not as now, laws of war, but laws against war, just as there are no laws of murder or of poisoning, but laws against them. So this was his call for what he would call the outlawry movement. That is the movement to outlaw war and to make it illegal. Which, again, sounds kind of crazy, but actually we live in the world that Salmon Levinson helped produce. And we owe a lot to him, this idea, this inventive idea that we could outlaw war, which seems so kind of fanciful, in fact became reality. First in the Kellogg-Briand Pact, and if you've heard of this, it's been probably mostly to make fun of it, I recognize. So I'm going to stay with me here for a moment. I'm going to try to convince you there's actually something important going on here. But Levinson spent a decade really trying to convince people that this was something that could be done. He started a non-governmental organization. He lobbied members of Congress. He went around the globe. He had various people who were advocating these ideas around the globe. Many other people got excited about this as a way to maybe prevent another war from breaking out in this interregnum, what turns out to be an interregnum period between World War I and World War II. And eventually it leads to a treaty that in the US is sometimes called the Kellogg-Briand Pact. In France they call it the Briand-Kellogg Pact. Named after their respective prime minister, well, in this case, a foreign minister and the Secretary of State. And this is the signing ceremony that took place in Paris. And in the Kellogg-Briand Pact, they actually decided to, in fact, to outlaw war. And from a modern perspective, it doesn't seem like such a big deal, but from looking at it from the perspective of a world where war had been the central way in which rules are enforced, and the central way in which states resolved their complaints against one another, this was a phenomenal shift in the way in which states would relate to one another. And so where the old world order had privilege at its core, privilege to use force at its core, and then these other rights that I explained kind of follow necessarily from them, the New World Order tried to shift that. But it was not seamless. This is an image of Japan's invasion of Manchuria in 1931. Japan and China had both signed the Kellogg-Briand Pact. Japan was present at the fancy signing ceremony to which only 15 nations were invited in Paris. And yet in 1931, war broke out and the world was again witnessing a major war between two significant powers. And the question was, how are we going to respond to this? How do we resolve this conflict? We just signed a treaty in every major country at this point. It became the most ratified treaty in the world at the time. Nearly every state had ratified this treaty saying that they wouldn't use war to enforce legal rules. And they had signed a treaty saying that. And traditionally the way in which they would enforce a treaty would be through threats of force or war. And so now you've signed a treaty preventing you from engaging in war. Now you have to figure out how are you going to enforce this set of legal rules, because you don't have recourse to the old system that you used to rely on. You can't rely on the same system, the same mechanism, that is use of force, that you would have relied on. And what they land on is this idea that they will prohibit force. They prohibit the use of military force. And then this whole set of other rules follow from it. And I'll explain how the rest of these rules follow from this shift. Oh, I think some of these slides get mixed up. So Henry Stimson, in answer to this question, what do we do? How do we respond to this war, this launching of this war by Japan against Manchuria, when legally we can't now use war to enforce these legal rules? They spent some time trying to figure this out, and Stimson, who was the Secretary of State at the time, came up with this idea, and he actually had been classmates with Salmon Levinson, and they were sort of engaging in correspondence. And so he was very much influenced by Levinson's thinking. And he came up with this idea that, well, we're not going to use force to enforce the legal rules. Instead, what we'll use to enforce the legal rules is we will just refuse to recognize that the territory that they're seizing as compensation is theirs. We're going to not recognize that conquest. We're not going to recognize that it's legal. We're not going to recognize that this land is part of Japan. We're not going to recognize the puppet government that they try to put in place. And we won't do any business with that government. We won't trade with them. We won't recognize their stamps. We won't recognize their marriages that they give. We won't recognize their passports. None of it. So Stimson wrote these 2 letters to these identical notes to Japan and China, where he says, the United States does not intend to recognize any situation, treaty, or agreement which may be brought about by means contrary to the covenants and obligations of the Pact of Paris. Pact of Paris is another name for the Calabrian Pact, it turns out. It has lots of different names, and maybe one reason why people don't realize that there's this through line in a lot of these really important moments. But that's what he's talking about. So he's saying it was illegal under the Calabrian Pact, and so we're not going to recognize this seizure of territory. And the League of Nations very quickly followed suit. So where there had been a right of conquest, now there's no longer a right of conquest. And note that that same note says that they're not going to recognize a situation, treaty, or agreement brought about by means contrary to the Pact of Paris. And notice that, remember, under the old legal order, under the old world order, gunboat diplomacy was legal. And here what he's saying is, even if you can get China to sign a treaty, we're not going to acknowledge that. Gunboat diplomacy here is not going to get you out of the problem. And so whereas it used to be lawful, that gunboat diplomacy used to be lawful, now it has been rendered unlawful. And that is reinforced after World War II in the Vienna Convention on Law of Treaties, which provides that duress is no longer permitted, and that any treaty that is brought about by means of duress, that is through coercion, through force, is now invalid. And in fact, at the moment that this was adopted into the Vienna Convention on Law of Treaties, which is now still a treaty that is observed by states and is a kind of key treaty that governs treaty relations, at the time there was a lengthy debate about whether this was going to be retroactive or not, because so many of the treaties at the time had been arrived at through coercion. And the problem was that if they were to undo that, many of the treaties that were in force would no longer be in force. They decided to not make it retroactive and only make it forward-looking. Many of the more powerful states, of course, were the key advocates of not letting it be retroactive and only having it be forward-looking. But this was a massive shift, and Lauterpacht in his commentary again noted that this was necessitated by the Pact of Paris and the fact that war was now illegal, so we can't recognize treaties that are brought about by threats of war, because that would render those threats lawful. And so where there was gunboat diplomacy, now there is no more gunboat diplomacy. Now look at the question of neutrality. Attorney General Robert Jackson, who later went on to become a US Supreme Court Justice, and he was also a judge at the Nuremberg Tribunal, he, during World War II, before the US had entered in, was trying to figure out if there was a lawful justification for the Lend-Lease program. And the Lend-Lease program was, as you probably remember, the program by which the US was providing significant weapons to the Allies, and of course not to the Germans. And the question was, well, is this a violation of neutrality? The US is not party to the conflict. Are we breaking international law by doing this as neutrals? And does this effectively mean that we're entering the war? And the judgment that he arrives at, and he gives this speech at the Organization of American States, where he says the Treaty for Renunciation of War, which is yet another name for the Calabrian Pact, by altering fundamentally the place of war in international law, has effectuated a parallel change in the law and status of neutrality. And in his view, meant that neutrality no longer required that there be perfect neutrality, but that they could favor the side that was the subject of an unlawful war, that you could favor the side that had been attacked and that was the subject of aggression. You could support them, you could provide arms, you could provide assistance, and that was lawful. And so where neutrality used to require perfect impartiality and kind of keeping complete equal treatment between belligerents, now neutrality permits partiality, and it includes allowing economic sanctions, which previously had been prohibited. And now that brings me to Nuremberg and the crime of aggression. Of course, at the end of World War II, the same question arose. Can we try those who are responsible for the war for the crime of aggression? And of course, many people said, well, we tried that before, and we decided that that was illegal, that we couldn't, there wasn't anything criminal about the launching of the war. The war wasn't illegal, so we couldn't have criminal responsibility for Kaiser Wilhelm II. So maybe that's the same now. And actually, there was an intense debate among the Allies about whether they could have trials and whether there was a lawful basis for actually holding the Nazis responsible for aggression. And they decided, well, actually there is, because Germany had signed and ratified the Kellig-Brand Pact, as had Japan, as had all the states that had been involved in World War II. And so they had agreed to outlaw war. And so something important had changed. The important thing that had changed was that war was now illegal. And if you look at the first count of the Nuremberg indictment, it says all these invasions had been specifically planned in advance in violation of the terms of the Kellig-Brand Pact. So this is an unlawful, illegal war, and the important shift that had taken place since the last time we asked this question was that we had outlawed war, and that the states, importantly, the states whose citizens they were going to try at Nuremberg and then at the equivalent, the IMT in Japan, had been party to the convention, had agreed to outlaw war. And so where it used to be perfectly legal to kill in war, and that there couldn't be any accountability for the crime of aggression, now aggression can be a crime. Now you might be asking, well, what's this have to do with today? We don't really talk about the Kellig-Brand Pact after World War II. It was really quite delegitimized, understandably. But the argument that Scott and I make in the book is that you can't understand the UN Charter without understanding that history, without understanding that foundation, that the Kellig-Brand Pact, and then putting all these pieces into place provided for the UN Charter. And in fact, there's an interesting connection between the people who were involved. The very person who ghost wrote the first proposal for the Kellig-Brand Pact for Brand actually wrote the first draft of the UN Charter inside the US State Department during this internal process when they were first working out the details of what this new international organization was going to look like. And in the very first draft that he wrote, he literally just cut and pasted the Kellig-Brand Pact and put it at the beginning of the UN Charter. And then through redrafting, it became the Article 2.4, which is up here, this provision that says all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. So this takes that same idea, this prohibition on war, that was really new, kind of a crazy idea that this guy Salmon Levinson had, that then became central to the Kellig-Brand Pact, that more states ratified that treaty than any other treaty that had been ratified at the time. And now that becomes this core foundational principle in the UN Charter. And gets in the Charter, what's new is not this idea of outlawing war, because that was now almost 2 decades old, but what was new is putting this whole structure around it, creating a system, creating the United Nations Organization, General Assembly, Security Council, International Court of Justice, a set of institutions meant to help maintain the peace. Because one of the core mistakes they made with the Kellig-Brand Pact was they just had this, literally it fit on a postcard, the whole agreement. It was extraordinarily brief. It was a commitment not to go to war, but they hadn't thought through the mechanics of it. They hadn't thought through, how are we gonna actually make this work? And they hadn't, I think, fully appreciated perhaps how much the international legal system to date relied on war as the core way in which the rules were managed and enforced. And they hadn't really thought through what the alternatives were going to be. Okay, so war in Ukraine. So almost 2 years ago, actually just over 2 years ago, the war began. And it looked like it was going to be just days before Ukraine was going to be swept up by Russia, and that its defenses were going to be overwhelmed, and that Putin was predicting it was going to be 3 days, and many people shared his view about how long it was going to take. But as you can see from this dynamic, initially there was a significant influx of Russian troops into Ukrainian territory, but surprisingly, Ukraine began to push back. And Ukraine has succeeded in pushing back significantly so that this, much of what has been held by Russia now continues to be the sort of eastern part of Ukraine, and it had taken Crimea back in 2014. And the war is continuing to be fought now on the kind of edges. There's been sort of a little bit of back and forth on the edges in eastern Ukraine. But against all odds, Ukraine has managed to hold out against the onslaught of a much bigger, much better resourced country with nuclear weapons that everyone expected was going to win this war in a matter of days, if not weeks. And when that war initially was launched, many people said, well, this is the end of the international legal order, if there ever was one to begin with, right? Many people thought, well, this is it. You know, if a large state like Russia can invade its neighbor and sweep in and take it over, you know, that's the end of the global legal order. And again, if there ever was one. Sadly, there is no international order, says Susan Glassard. But there's views here that were expressed, and these are only two of many, where people are saying this is the end of the international legal order. And I want to say that there's no doubt that this is the greatest threat. I think it's not that there's no doubt that this is one of the greatest threats that we face to the modern international legal order since World War II. But it's not just whether the war has been waged and not just whether Russia has tried to invade, but what the response has been, and how the rest of the global community has pressed back against Russia. So I want to say a bit about that. So first, there was condemnation of Russia and of this invasion. The General Assembly, within a matter of a few days, managed to pull together a resolution that was voted through with a sweeping majority. Over 140 states voted in favor of this resolution, and just a handful of states, only 4 states, voted with Russia against this resolution condemning Russia's invasion of Ukraine. And it specifically stated that it was deploring the aggression by the Russian Federation against Ukraine in violation of Article 2.4 of the Charter. So they made it clear that this was seen as an illegal war under the UN Charter, and it's the core rules of the international legal system that were being violated by this invasion. And as I said, there was a vast majority of states voted in favor. There were some states that abstained, and I'm going to say a little bit more about that, but only 4 states voted with Russia in favor against this resolution, over 140 states voting to condemn Russia and its invasion. Now, second, in addition to just condemning what Russia was doing, there was significant sanctions and what in my work I've called outcasting. So outcasting is essentially, as I say here, involves denying the disobedient the benefits of social cooperation and membership. What do I mean by that? One of the examples of this is economic sanctions. It can also be kicking you out of international organizations. The G8 is now the G7 because Russia has been excluded. It can be refusing to do business, engage in diplomacy, enter into new international treaties. It can be a whole range of various kinds of actions that deny a state the benefits of being part of the global community, the full benefits of being a member of the global community in response to their illegal behavior. There has been among the most significant sanctions put in place against Russia of any sanctions regime outside of a Security Council mandated regime. And this is just a kind of small handful of the states that have been part of the effort to sanction Russia and put in place significant sanctions on Russia, in particular its energy sector, but also high-level technology that it doesn't have easy substitutes for, which is maybe in the long term, a more important part of the sanctions regime. But large number of states joining into the sanctions. Now remember that under the old world order, this would have been a violation of neutrality. Sanctioning one side and not doing the same thing for the other would have been a violation of neutrality, which would have brought all these states into conflict with the state that they were sanctioning. But under this transformation of the understanding of neutrality, that's no longer true. And states can sanction an aggressor state and not have to fear that they are, by doing that, being brought into the war. The Russian Federation was also excluded from the Council of Europe. This is another form of outcasting. It was kicked out of the Council of Europe. It's no longer a member of that organization as a result. And it was suspended from the Human Rights Council by another General Assembly resolution that voted to exclude it. And this is just a few of the many votes that have been taken to try to exclude Russia from the kind of global community in various ways in retaliation for its illegal war. Third, in addition to kind of condemning and outcasting, states have also joined in assisting Ukraine, which is in some ways maybe the most important thing that they've done. Providing military assistance, providing financial aid and assistance that have made it possible for Ukraine to push back. Because without that, it's clear, Ukraine would have just been heavily out-resourced almost instantly. They just didn't have the weaponry, they didn't have the ammunition, they didn't have the resources to be able to push back. And they've been assisted extensively by large numbers of states, most importantly the EU, but also the US and a number of other states. Canada's up there in the top group of states that are providing the significant assistance. And they're doing so in part because they see Ukraine as fighting for something important, not just for Ukraine itself, but they see Ukraine as fighting against a state that is claiming to basically upend these rules of the modern international order and claim that they can go in and take territory from a neighbor state and get away with it. And I think what this is saying, what most of these states that are assisting Ukraine are saying, is we don't endorse that, and we want to assist Ukraine in pressing back against Russia's efforts. Fourth, there have been efforts to prosecute Russia and Russian citizens for their role in this illegal war. The International Criminal Court has jurisdiction over the situation in Ukraine because Ukraine has consented to the jurisdiction of the court. And so this is Karim Khan, who is a prosecutor of the International Criminal Court, and there's ongoing prosecutions and investigations of the situation in Ukraine. And they've already issued one indictment of Putin and Maria Lvova-Belova for their seizing Ukrainian children and forced adoptions and conversion, and trying to kind of cause them to no longer speak Ukrainian, forcing them to speak Russian, engaging in education, adopting them into Russian families, and otherwise violating international law, and particularly crimes against humanity, by seizing these children. That's the first indictment that the International Criminal Court has issued. Certainly there are going to be several others. They're engaged in an ongoing investigation of the situation in Ukraine. I've been working on this question of how to try the crime of aggression. I'm happy to say more about that. I said a little bit about it at lunch for the faculty who were there. But there's an ongoing question about, so I mentioned the crime of aggression was a kind of innovation of the modern world order. That is one of the crimes that's in the ICC statute, the International Criminal Court statute. But it can't be prosecuted here because there's a jurisdictional limitation just on the crime of aggression that says that it can only be charged against a state that is a party to the Rome Statute. That's the statute that creates the International Criminal Court, which I'm happy to get into politics of that if anybody has questions during Q&A, but is the reason that Putin can't be charged for waging the illegal war right now. But there's efforts to change that. Okay, so there's a number of challenges that have been revealed through this process. And I want to walk through a few of them. This is not going to be comprehensive, but it'll cover some of the core challenges that we've seen as a result of the war. One question is, I've mentioned all these sanctions. There's a massive sanctions regime, but there's real questions as to how well those sanctions are working. Are the sanctions really causing Putin to do anything any differently? How much of an impact is it actually having? So much of its currency reserves are being frozen. Over $300 billion in Russian assets have been frozen, and Canada, in fact, has a law that allows a seizure of Russian central bank assets, though they have not yet used them against that law against central bank assets, and I'm happy to talk about that law, but they've used it to seize some Russian oligarch assets. Russian firms are barred from buying inputs and from engines to chips, and in particular, a lot of the sanctions are aimed at technology that's not easily substitutable, so that it's technology that is only available from a few sources, where they're not going to be able to easily get it from other places. The impact is likely to be long-term, not short-term, but it's an effect to kind of bend the long-term cost curve. And in the long run, the intent is to impair the productive capacity and also to impair the ability of Vladimir Putin to continue, if he decides he wants to launch this war elsewhere, and to continue into other countries, which he certainly hinted at, that he'll have fewer reserves to do that. But there's still real questions as to how effective these sanctions have in fact been. The trends in oil revenue have been to go down. The total revenue from the fuel export has been going down since the war began. And so in that sense, it seems like that's a sign that sanctions have been working pretty well. But some states have been increasing their imports of Russian fuel. In particular, China and India have significantly increased their willingness to buy these oil resources, and so they have depressed the impact of these sanctions and meant that the sanctions are not as effective as they otherwise would be. And this is a kind of longer accounting. You can see a number of states kind of increasingly at the top. Turkey and China and Saudi Arabia and UAE are buying oil products. China and India are buying a lot of crude oil. China and India are buying a lot of coal. So you can see a pattern here, right? Number of states that are willing to buy these assets, buy this fuel, even though it's sanctioned. And so that is having an impact that deadens the impact of the sanctions. So sanctions are still having an impact, as you can see from the downward curve in terms of their fuel revenue, their revenue from oil, from selling various kinds of fuel, but it's deadened by the fact that other countries are willing to step in and buy that oil. And another challenge that this, I think, helps reveal or at least suggests is this concern that maybe we're seeing this splintering in the global economy. This is an article in the Atlantic, claiming the world is splitting in two. Maybe a little bit kind of overstating it, but I think there is this concern that as we end up having, many states sanctioning Russia and refusing to do business with Russia, but other states stepping up and being happy to do business with Russia and buy the very same oil and fuel resources that we're refusing to buy, that you're seeing this bifurcation of the global economy. And that you have some states lined up on one side and other states lined up on the other side, and this potential for splintering of the global economy that could affect growth around the globe. And there's real concerns that might be part of what is unfolding as a result of a sanctions regime like this. Another concern is a concern of the West versus the rest. So I showed you this earlier, but if you look at it closely, you can see that many of the abstentions and non-votes are coming from Africa and Asia. So while still a majority of states in Africa and Asia did vote in favor of the General Assembly resolution, and these votes there's I think been 6 more of these resolutions, and the votes look roughly similar. The majority of the states in these regions did vote in favor, but there were significant numbers of states that stayed on the sidelines, that abstained, that did not want to kind of pick sides in the fight. And it raises a real question. I think it's a reason for real introspection about why it is that so many states in the global south, particularly in Asia and Africa, don't see their interests reflected in this condemnation of Russia's illegal war, and why it is that they don't see themselves and their own interests being served by these resolutions. And I think it invites and calls for a conversation and really trying to understand and get to the heart of what is causing this divide in terms of the commitment to the global principles at stake here. I think there's real questions too about whether the global order of the criminal justice system is really up to the task. The ICC has never faced this kind of an investigation before. There are thousands of investigators around Ukraine. There are thousands of possible cases that Ukraine could take up, and they're incredibly technically complex cases. I just finished work on a report that I think is being released today or tomorrow, looking at using never before really used technology to try and identify all the parts of the electrical infrastructure that have been targeted by Russia in the conflict. And it uses satellite technology and various kinds of open source technology to try and trace in a way that's never really been done before in using these technological tools, the targeting of this electrical infrastructure by Russia, and tries to document what's happening. That's a huge amount of information for the prosecutor to try to go through. And in the report that I worked on with the Conflict Observatory, which is based at the Yale School of Public Health, it took 20 researchers with specialized expertise 6 months to produce this report. And they just don't have that kind of expertise in the ICC. And even then, we weren't able to document who is responsible for which attacks and who exactly ordered this attack or that, so that you could hold them responsible. And that's the kind of information the ICC is going to have. So this is an immense task that the ICC faces. And there's just, it's going to be an incredible task. And meanwhile, there's some infighting that's been going on. The ICC doesn't really like the idea of a special tribunal. The ICJ has been weighing on certain matters. The ICC would rather have it be sort of primarily their turf. And so we're going to see how this all plays out. I think there are questions as to whether the system is going to be able to hold, given the kind of weight that's being put on it. And can Ukraine survive the next stage of the war? I think this is a real question. Putin has said that they wouldn't last a week without Western military support. I don't know if that's quite accurate, but it is true that they do depend deeply on all the states that are providing arms and ammunition and financing and other kinds of intelligence and other kinds of support, without which there's absolutely no doubt they would not have lasted as long as they have. And if that support dries up, if the ammunition stops being sent, then it's just going to be impossible for Ukraine to defend itself. Obviously, the United States has been the kind of laggard here. The Congress has been unwilling to vote in favor of an aid package, which is sorely needed. It has been interesting to see that a number of other states have stepped up. So you've seen smaller packages from a number of other states come through, which has been important to kind of keep Ukraine going. But if that support was to dry up, probably Ukraine would have to fold. And that is, that would be, I think, really hard blow for the international legal order. It would mean that Russia would undoubtedly seize significant territory from Ukraine, if not all of Ukraine, and that we would see a real transformation in the global legal order, that states could no longer count on this prohibition on use of force. They could no longer count on the idea that conquest is no longer going to be permitted, and we would see a very different kind of world unfold. And we've already begun to see this. Avdiivka, which had been long fought, just recently fell, and the Ukrainians at least suggest that that was in part because they just didn't have the ammunition to be able to keep up the defenses. So this is not a kind of false warning. I think it's a real concern that in fact we could see a shift in this war very quickly if money doesn't keep flowing in support of the Ukrainian effort. Okay, so what's the impact of the war on the global order so far? And I say so far because we can only say what we've seen. There's a lot of contingencies that are hard to predict. Is that aid package going to come through? I was reading just today that maybe they have a deal, but I keep seeing maybe they have a deal. And if Trump gets elected, almost certainly the U.S. will stop supporting the war effort. So there's a lot of contingencies ahead. But so far, there's some very hopeful elements of this. You have seen a real revitalization of the role of the General Assembly, which has been core to the UN's response to the war in Ukraine. It has voted again and again with very significant majorities in favor of these resolutions, which have been really consequential. They've been consequential not just because they condemn Russia and call out its actions as illegal, but by doing so, and doing so with these very significant numbers in support of these resolutions, it has, I think, made possible the support and assistance that then has flowed behind those resolutions. Without those resolutions, states, I think, wouldn't have the same kind of confidence that they do, that they're supporting the side that's right in the war, and that there's a global consensus around that. So that has been really important. And important as well is this evolution of a new mechanism, sometimes called the veto initiative, which has been leading to allowing the referral, the automatic referral of any vetoed resolution from the Security Council to the General Assembly, and has been part of that kind of revitalization of the General Assembly as part of the UN's response to crisis. We've also seen a revitalization of the International Criminal Court. I said that the ICC has never had this kind of a task before it, but it's never had this kind of support either. The US and many of those who are fond of attacking the International Criminal Court suddenly have become big enthusiasts of the ICC now that it's going after Putin. And so I wrote this op-ed in the Washington Post. The US finally sees the point of the International Criminal Court when the US passed a law basically allowing an exception to the American Service Workers Protection Act, which generally prohibits US collaboration and cooperation with the International Criminal Court, but now allows it for assistance with prosecutions involving the situation in Ukraine. And that collaboration, I think, is really strengthening the ICC, is giving it access to a lot more resources, the capacity to do more than it used to. And now I think people are increasingly seeing the ICC as maybe a valuable tool in responding to atrocities and responding to illegalities and holding even the most powerful nations to account for their actions. There's been renewed attention to the prohibition on war. Much as this has been a terrible blow for the international legal order and a challenge to the international legal order, it's been remarkable to see how many people now are talking about how important the prohibition on force is. And if you listen to some of these Security Council meetings, as I sometimes do, you hear these speeches from members of the Security Council saying, you know, this is fundamentally important for us to stand up for the rule of law and for the international legal system and for the prohibition on use of force. This is essential in its core to the international legal order. And I think I couldn't have written it better than myself. This is exactly what I have been trying to argue for a while. And I think increasingly people are maybe less willing to take for granted that we're going to live in a world in which states recognize that they have this prohibition on their use of military force by one state against another. And I think a renewed realization that that rule is fragile and it needs to be maintained and protected. But the long-term effects are still to be seen. There's so much that we don't yet know, and this is just some of it. Will the global economy fracture, or will the forces that are holding it together just prove too strong? This is the splitting in two question. Are we going to split in two or more? Or are we going to find that in the end that these connections of trade and globalization are too strong and in fact it's going to hold us together? Will Ukraine's allies stay the course? Are they going to continue to fund and support Ukraine in its effort to respond to the illegal invasion? Or are they going to run out of willingness to provide money, provide arms, provide ammunition? Will that support dry up and Ukraine's ability to defend itself dry up along with it? What will China do? That is a big question. It's been very interesting that China has been sort of staying on the sidelines here. They've been buying more fuel, that's true, from Russia, but they have abstained in all these Security Council resolutions, and they have not been selling arms to Russia. And that's part of the reason that Russia has had to go to places like North Korea and Iran to try and get arms and ammunition because it can't get it from China. And so China has not been a full-throated supporter of Russia in this effort, and assuming that it continues to stay on the sidelines in that way, that actually is important to kind of restraining Russia's ability to engage in a full-fledged war against Ukraine and its neighbors. Does Putin have the internal support to continue to carry on this war? And there has been significant losses of Russian forces. And so far, it seems that he's not borne a significant internal cost to this. But one has to wonder how long that can go on. The asymmetry in the casualty rates between the two states is really quite stunning. And many of these Russian forces that are sent into the field are extremely ill-prepared and ill-equipped and are getting mowed down at a pretty substantial rate. Many of them are coming from themselves, from ethnic minority regions of Russia and being sent to Ukraine, conscripted and sent to fight in Ukraine. They don't particularly have any say in the fight or particular interest in the fight. And there's a question as to like, at what point does that become politically untenable within Russia? Will it become politically untenable, or is his ability to crack down on internal dissent strong enough that he's going to continue to maintain power? Can these international justice systems live up to their promise? You know, are they going to deliver, or are they going to prove an incredible disappointment? And more recently, the question of whether the war in Gaza is going to drain some of the support for Ukraine and erode the capacity of global institutions, which are themselves losing some legitimacy in the face of the extraordinary humanitarian and human crisis that's unfolding there. So these are the questions that we all face, and the answers to these questions are going to determine the future of the international legal order. And I say to my students, and I will say to you, that these are not questions that are sort of determined out there. I mean, these are people who are working hard to try and shape the global legal order around Canada, around the United States, and governments around the world who are trying to answer these questions in the right ways, that are working hard to bring true accountability, to continue to provide support to Ukraine, to reinforce and support these central principles of the global legal order. And it's going to come down to people like that around the globe, doing that hard work and trying to support these central principles that is in the end going to determine the answer to these questions. So with that, I look forward to your questions. Do you want to sit here? I've got mine. Yeah.
Well, thank you very much, Oona, for that extraordinarily far-ranging exploration, not only of the history, but in of our current time and place as well. We have about 25 minutes for Q&A. We intend on this being informal. We have 2 mic holders, so I'm just going to ask you raise your hand. And my only request is that you just introduce yourself to the room when you have an opportunity. We'll try to please one question per person, not one question broken into 3 separate questions. One question, please, so as many people as possible get an opportunity. Please.
Thank you. Well, this is a really powerful microphone. To introduce myself, my name is Peter Roth, alumni UBC 1996. Thank you so much. That was fantastic, Professor Hathaway. Very far-reaching. Very quick question. I would like to take you up on your invitation, of your offer to speak a little bit on Canada's actions vis-a-vis the seizure of Russian state assets, as opposed to the seizure of oligarch assets.
Yeah.
Your thoughts on that, the reasoning behind it, and anything you can offer with respect to Canadian perspective.
Yeah, great. Thank you for that great question. So there's a challenge. The seizure of Russian oligarch assets is easier legally because you don't face the challenge that you face with seizure of central bank assets, which is the doctrine of sovereign immunity. So under international law, there's a doctrine that basically says states are supposed to not interfere with one another's assets in a significant way. So they're not supposed to seize one another's assets. They're not supposed to subject one another's decisions to the judgment of one another's courts. And the question that has emerged in this whole debate about whether to seize the Russian central bank assets, which are being frozen right now, significant, 300 billion, most of them being frozen, by the way, in Europe, not in Canada or the US, just small numbers in Canada and the US. the concern that has been raised is that seizing those assets and giving them to Ukraine would be a violation of sovereign immunity. And there's been a lot of effort to try and think through how you could legally get there. But Canada is interesting because it's the one state that has sort of like got it on the books that it could go seize those assets. But everybody else has been debating it. The US Congress has been debating it. The EU has been debating it. And everybody else is sort of hamstrung around these legal questions. I will say that my own view, and I've written a very long law review article about this if anyone's interested. It's called War Reparations, The Case for Countermeasures. It's posted on SSRN. You can freely download it. And where I go through why I think, unfortunately, much as I believe deeply in the Ukrainian cause, I don't think that seizure of the assets and giving them to Ukraine would be lawful under international law. And so what I argue for instead in that paper is continue to freeze those assets, continue to hold them indefinitely, unless and until Russia not only ends the war, but also provides the reparations that it's legally obliged to provide to Ukraine. And then I make an argument for how that should be done in coordination with the United Nations. I will say that I'm an executive editor for a blog called Just Security. So if you're a international law or foreign relations kind of geek as I am, this you might enjoy this blog. It's called Just Security, and we have a ongoing series on war reparations on there. And one of my former students, who's a Canadian lawyer, actually wrote something specifically about Canada, just posted last week. So if you're interested in reading that, and there's a bunch of people with different views, including views that are contrary to my own. We invited people who had different perspectives to write on this. So you can see a variety of different perspectives on this question. But yeah, I wish I could arrive at the conclusion that it would be legally okay to seize the assets. But I'm a believer that international law is only valuable if you follow it both when it's convenient and when it's inconvenient. In this case, it's inconvenient to come to the conclusion that international law prohibits it, but that's unfortunately the view that I've come to. And so I think we have to abide by that. I don't think it's in Ukraine's best interest to try to address one illegal action with another, because one of the core strengths of Ukraine's war has been the fact that it's on the right side of the law, and that it has gained so much support from so many states around the world, I think in part for that reason. And I think that if you start breaking the rules, that potentially undermines that support, which is so essential to its ability to continue to sustain its war effort. So that's a long-winded answer to a simple question, but hopefully helpful. Good.
Where's our next? Oh, please.
Thank you. Thank you, Professor Hathaway, for your amazing lecture. This was so comprehensive. I took a class in international relations last semester, international law, sorry, and this really brought all of it together with the and everything. So I'm a fourth-year international relations student. My name is Tanya, and my question to you is to elaborate a little bit about the politics of the Rome Statute, as you mentioned, as well as the debate of ICC versus ICJ jurisdiction, because you mentioned that, so I'd like to.
Yeah, great. So where to begin? I'll try not to make this too long. So you all may be familiar. The International Criminal Court is a court that was founded in the early 2000s. And the idea behind it was we had done a bunch of these ad hoc courts. We had done the International Criminal Tribunal for the former Yugoslavia. We did an International Criminal Tribunal for Rwanda. We did a special court for Sierra Leone. We were doing a bunch of these individual courts for various atrocities. And the thought was, each one of these is so expensive, because every time you do this, you got to reinvent the wheel. You got to set up a new court. You've got to have a set of rules. You've got to get a bunch of judges. You've got to find a building. I mean, it's a lot of work, and it takes forever. It took the ICTY like 20 years to get going to actually start having these cases. So the thought was, well, we have a standing court that would be able to adjudicate the most egregious crimes. So the crimes in the Rome Statute are crimes against humanity, war crimes, genocide, and the crime of aggression. That fourth one was controversial. the crime of aggression. The United States very much opposed it. It wanted not only that, but many other, essentially what it would have liked to have is an international criminal court where it could only get jurisdiction by referral from the Security Council. The rest of the world, of course, did not much care for that vision because it just gives the US, obviously a veto power over any referral that's, and Russia and China and France and the UK, veto power over what crimes are going to be prosecuted, which is terrible from a legitimacy perspective because that leads to extraordinary selective prosecution. And so the US lost that fight. There was this court that was set up. The US did not join it. But because there was so much controversy about the crime of aggression, they decided not to define it in the sort of initial, when they first concluded the Rome Statute, and say that it couldn't be prosecuted until they could agree on a definition, which they finally did about a decade later in what's called the Kampala Amendments. But when they made those amendments in a concession to the US, how did the US manage to do this? Well, the US was at the meeting as a non-party state and had many forceful arguments that it made to get a carve out, and the UK was also supportive of this carve out, that basically said you could only bring prosecutions for the crime of aggression against state parties. And now, ironically, that's exactly what's protecting Putin. Because now we can't prosecute Putin for the crime of aggression because we did this carve out. Now there's a move to try and change that. So there's an ongoing debate about whether to amend the Rome Statute to make the jurisdictional rules the same for the crime of aggression as for the other crimes, which would mean that going forward, the crime of aggression could be prosecuted if you're either a party to the Rome Statute or if you commit your crimes on the territory of a state that has agreed to the jurisdiction of the court. So there still has to be some form of consent, but you consent either by consenting to being a party or by committing your crimes on the territory of a state that has. That is going to be a long political fight. There's some people who think the crime of aggression is inherently political, it's not legal, so we shouldn't have a court adjudicating it. I think it's not any more political than the other crimes. And if we believe that this is a core principle of the international legal order, as I do, and if we think that this was an important innovation of the post-war era, which I do, and if we think that all states should be held to the same standards, which I do, then I think we should have that as a legal obligation in the Rome Statute. And then states could protect themselves to some degree by joining the Rome Statute, because that would mean that any state that invades them, their leaders could be prosecuted in the International Criminal Court for the crime of aggression because they would be committing their crime on the territory of that state. And I think that could be a powerful incentive to states to be party to the Rome Statute. So I'm a believer in law. I'm a believer in using law to the ends of trying to support these legal systems. And I also will, just last point, I see that the crime of aggression is part of this broader network of rules that we create. It's not just the crime of aggression by itself. It's that the crime of aggression is reinforcing this broader legal order that is built on this foundation of this principle that states should not be able to use force against one another to achieve their ends, whether they're legal or not. And having a crime of aggression that could be enforced is an important message to the global community that this is something we actually believe in, and that we're going to have criminal liability for it. We can have, we have the UN Charter, that we have other ways of enforcing, and we're going to provide aid and assistance to anyone that's subject to any illegal aggression. But I think the crime of aggression is a piece of that puzzle. But I have many good friends in Washington that don't necessarily see it that way, and we'll continue to have conversations about this until hopefully the US comes around. And many other states, of course, the US is not the only one. So hopefully that answers your question.
Where was the next question? Thank you. Please.
Hi, good day. My name is Stanley Trump, a political science graduate in 1997. And thank you for your presentation. It's most enlightening. I have a question about China and its this factor might explain its official neutrality anyways, and that is if Russia succeeds, then might it embolden China to invade Taiwan, or even other countries to invade other ones in the future?
Yeah, I mean, there's lots of speculation about this, right? And there's speculation both directions. One source of speculation that I actually find fairly persuasive is that China was surprised by the kind of response that Russia met for its invasion of Ukraine and the kind of global reaction that it provoked. And that there has been a little bit of a kind of second thoughts about whether China wants to risk that itself. So China, if it were to invade Taiwan, this concern would be, would states, put in place sanctions against China? Would they resist in the same way? Would they support Taiwan in the same way? That's a question that I think has been raised. But if Russia wins, if Russia succeeds in seizing significant parts of Ukraine, and if states eventually concede to acknowledge that conquest as lawful, then that emboldens not just China, but it emboldens everyone. I mean, every state that has a neighbor or another state that has territory or resources that they find appealing, that they might want to seize. If those rules are no longer applicable to in the same way, then we might be seeing ourselves, heading back towards something like the historical system. And the historical system, which was not that long ago, it's important to remember, we're talking about a transformation that dates to 1928, was one in which states did regularly invade their neighbors and take their territory. And that was sort of ordinary course of business. And the worry that I have is that, if Russia wins, that may be a start of an evolution back to the old world order system where we can no longer count on the rules to maintain our safety and security. And that would be, I think, a really a path towards a much more dangerous and deadly world. So that's one of the reasons that I think this matters so much. And I think it's the reason that much of the world thinks it matters so much. I mean, I think that you don't have so many states willing to support Ukraine because they care all that much about Ukraine. It's because they see this broader principle that's at stake.
Where's our next one?
Hi, I'm Sean. I graduated from this department a while back. I want to reference two things. Resolution 84 during the Korean War, at the beginning of the Korean War, and the resolution of the U.S. coalition to defend Kuwait. How do they differ from this situation? What could have been done prior at the UN?
Well, so yes, there are questions of could the UN have done more here? And certainly the Security Council, I mean, if you didn't have Russia with a veto here, then you could have had Security Council resolutions authorizing, maybe even requiring a response. So for instance, Security Council has the capacity to mandate sanctions. The sanctions regime that we have in place right now is all voluntary. Every state that is sanctioning Russia is doing it because they've voluntarily chosen to put in place those sanctions. If you had a Security Council resolution, you could mandate it. But sometimes people make the mistake of thinking that, well, if only the Security Council would have voted, then we would have a more forceful response. We would have states, sending their troops to defend Ukraine. And I don't think that that is true. And the reason that I don't think that it's true is that legally, states already could do that. The reason states could already do that is that under the UN Charter, under Article 51 of the UN Charter, states have a right of self-defense, and they have a right of collective self-defense. So a state can invite other states to help them defend themselves if they're lawfully engaged in a defense under Article 51, which there's no doubt Ukraine is. There's zero doubt that Ukraine is fighting against an unlawful war, an armed attack by Russia. And so what's stopping states from sending troops, although apparently Macron has been proposing this recently, and he's been kind of shut down, but But the reason up until now, at least, that states have not been sending troops to support Ukraine is not because the Security Council hasn't authorized it, but because of fear of confrontation with a major nuclear power. And so I think what has been causing states to hold back is the fear of nuclear Armageddon, not because they lawfully can't, because they lawfully can, even though the Security Council hasn't authorized it. Whereas with the Korean conflict, it was much more complex. Potentially with the Kuwaiti conflict, you probably could have similarly done a collective self-defense argument on behalf of Kuwait, but it was significantly strengthened by having the Security Council resolution authorizing it.
We have time for one more question. Where's the microphone at, please? Please.
Joseph Whiteside, class of '83. Your last page had the critical question, what about the Allies staying united?
Yeah.
And it seems to me critical that on all the other questions are impacted by that. China will back off if the Allies stay united. So the question is, within your work, what do you see as mechanisms that help strengthen the Ally cause within legal mechanisms to help ensure, both in the case of Ukraine and subsequent actions, that there is a strengthening of mechanisms rather than a splitting of interests, as we see with Hungary, spinelessness, the United States not being clear what its long-term goals are, et cetera. I'll leave it at that. Thank you very much. Wonderful presentation.
Thank you. No, it's a great question. It's one that I spend a lot of time thinking about. I mean, I do think that part of it does come down to where the publics are, you know, what kind of support, political support there is in these countries for continued support of Ukraine. Because when political leaders think that the public doesn't support what they're doing, that does make it much harder for them to continue to sustain this effort. It is true that these sanctions, particularly in Europe, mean the energy prices are higher. It means the consumer prices are higher. And, you know, people don't like paying more for things. And so part of the job, I think, that, you know, I see myself having as an academic, but I think that, that those of us who believe in this cause have, is to try and explain why we think this is so important. You know, so events like this is a part of how I think part of my role in trying to explain the importance of continuing to maintain support for Ukraine. I think that for political leaders, they need to do more to explain to their publics what's at stake. You know, that this is, again, not just about Ukraine, but this is about our own self-interest. This is not about defending Ukraine. It's about defending Ukraine, but it's not just about defending Ukraine. It's about defending the global legal order and peace and security that we've enjoyed for decades. And that if that system begins to fall apart, then we're going to be spending a lot more on our defense. We're going to be a lot less secure. We're going to be a lot less stable. We're going to be spending a lot more on a lot of these things. And we're going to be in a much more brutal world where lives are going to be much more at risk, and where we can't count on the kinds of peace and security that we've been able to count on for much of the last 80 years. And so I think we need to do a better job of explaining that. I think there hasn't been as good of a job of explaining that. And so people see the billions of dollars and this price tag, and they're like, wait a minute, why are they getting billions of dollars? Like, we need billions of dollars too, you know? And they're right. I mean, it would be much better if you could spend that money on, you know, education and other kinds of, you know, social and programs. But this is important too. And if we let this slide, if we let Putin succeed here, if we let the global legal order decline and be eroded through his success in Ukraine, that's just the first step. And unfortunately, we're all going to be paying the price down the road. So it's better, I think, to try and maintain this effort now so that we don't have to pay that cost later.
Wow, I wish we could keep going. But we are on a schedule. There is food, and there is drink. I would invite you all, please, to the enjoy the reception afterwards, mingle, talk to each other, meet one another, remember Mark. It was about community. It was about bringing people together. So I hope in his spirit you will do that this evening. It just remains for me then to please ask you to join me in welcoming and thanking Professor Oona Hathaway here this evening. Thank you so much.
Thank you. Thank you. Thanks so much.